I call this meeting to order. Good afternoon to all. Welcome to meeting number 98 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April 24, 2023, the committee is resuming consideration of Bill C-27 to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. I would like to welcome our witnesses today. We have Michael Beauvais, who is a doctoral candidate, Faculty of Law, University of Toronto. He's joining us by video conference. Good day, sir. We have Avi Goldfarb, Professor of Marketing, and Rotman Chair, Artificial Intelligence and Healthcare at the Rotman School of Management of the University of Toronto. We have also Ms. Michelle Gordon, lawyer and founder, GEM Privacy Consulting, and Mr. Antoine Goulma, counsel and co-leader, National Cybersecurity and Data Protection Practice Group at Gowling WLG. And then from IQVIA Solutions Canada, we have Luc Arbuckle, Chief Methodologist and Privacy Officer. Each of you will have 5 minutes. I'm terribly sorry if I mispronounced any of your names. This often happens, and my name is often mispronounced as well, especially in French. But welcome to all of you. Thank you for having taken time to come and join us in this study this afternoon. Without further ado, I recognize Mr. Beauvais. 5 minutes, sir.
And members of the committee for today's invitation. I'm a doctoral candidate at the University of Toronto's Faculty of Law and graduate fellow of the Schwartz-Reisman Institute. I have more than a dozen peer-reviewed publications and numerous policy interventions on privacy and data protection law in Canada, the European Union, and the United States. I submitted a brief on children's issues in the Consumer Privacy Protection Act with my colleague, Leslie Reagan-Shade, who is a professor at the University of Toronto's Faculty of Information and faculty affiliate of the Schwartz-Reisman Institute. I'm here today in my personal capacity. Children's privacy in the digital environment is essential for their agency, dignity, and safety. Indeed, data protection laws are one important piece of a response to mounting evidence that corporate surveillance and persuasive design are undermining children's agency and well-being. At the same time, though, digital technologies are vital for children's inclusion and participation in society. Members of the committee, you are in a special position to help ensure that the digital environment aligns with children's rights. Before highlighting a few of the recommendations made in our submission, let me note that the UN Committee on the Rights of the Child has consistently recommended more robust and standardized mechanisms for meaningfully obtaining children's views on legal and policy matters affecting them. It is thus regrettable that there is no evidence of youth consultation for this important bill. I respectfully urge you to solicit their views. Now let me briefly discuss our recommendations. First, several key definitions need to be clarified. These include a definition of a minor and a definition of capacity to determine when a minor is, quote, capable of exercising rights and recourses under the Act. The Act must also clarify the scope of and relationship between parental and child decision-making. Additionally, more specification is needed with what happens when minors reach the age of majority. Information about one's childhood should furthermore remain, quote, sensitive information, and, quote, even after one has attained the age of majority. Second, the best interests of the child should be included as a fundamental principle in the Act. Doing so would make the child's interests a primary concern in all aspects of the proposed legislation. For example, the best interests of children should matter in specifying the purposes of data collection, use, and disclosure, as well as data retention. Third, age and parental consent verification requirements and limitations are needed. Treating minors and adults differently makes verification for both age and parental consent an important part of compliance. Such verification, though, can be highly intrusive, unreliable, and insecure. Verification also poses serious threats to freedom of expression of all Internet users. Fourth, the Office of the Privacy Commissioner should be mandated to develop a children's design code with meaningful participation from youth. Design codes are age-appropriate standards for youth-directed products to ensure that the highest level of privacy by design. They also help ensure that youth-directed products do not undermine children's rights. Businesses also welcome the certainty that codes provide. Since codes only elaborate on general principles and obligations arising from the legislation, robust protections for privacy and agency must be in the law itself. Finally, kindly recognize that providing robust protections for children should not be a justification for meager protections for adults. Before concluding, I want to respectfully remind the committee that the ongoing lack of high-speed internet access among Northern, rural, First Nations, Inuit, and Métis communities deprives children and adults alike in those communities from the same opportunities found elsewhere in Canada. The CPPA's promises and potential are illusory without equitable access to the internet. I appreciate your work in this important study, and I look forward to your questions. Thank you.
And now I recognize Professor Goldfarb. Over to you, sir.
Kind invitation to appear before the committee and discuss Bill C-27. I'm Professor of Marketing at the University of Toronto, where I hold the Rotman Chair in Artificial Intelligence and Healthcare. My research focuses on the economics of information technology, including several papers on privacy regulation and on artificial intelligence. Canada is a leader in AI research. Many of the core technologies underlying the recent excitement about AI were developed right here at Canadian universities. At the same time, our productivity is lagging. My research has shown that AI and data and related data-focused tools are particularly promising technologies for accelerating innovation, productivity, and economic growth. In my view, a big worry for the Canadian economy going forward is that we do not have enough AI. And so our standard of living, including our ability to fund healthcare and education, would stagnate. It would be a shame if Canada's research success did not lead to applications that increase Canadian prosperity. This act is a careful attempt to ensure that Canadians benefit from AI and related data-focused technologies while protecting privacy and reducing the potential of these technologies to harm individuals. Next, I'll provide specific comments on AI regulation in Part 3 and on privacy regulation in Part 1. 5 specific comments on the Intelligence and Data Act. First, the Act correctly recognizes that there is always a human or team of humans behind decisions enabled by AI. Part 1, Section 5.2 is commendable for noting that a person is responsible for an artificial intelligence system. Section 7 through 9 make these responsibilities clear. In my experience, such clarity about the role of humans in AI systems is both unusual and commendable. Second, the Act constructively defines explainability and transparency in Part 1, Sections 11 and 12, by making it clear how and why the high-impact system is being used. Rather than focusing on the inner workings of the algorithm, it'll provide useful information without forcing potentially misleading oversimplification of how the algorithms work. Third, while the details of the Act itself implicitly recognize the role of AI in Canadian prosperity, the preamble to the AI and Data Act does not recognize technological progress is fundamental to our prosperity, and instead focuses only on regulation and harms. Fourth, there are 2 sections of the Act that might create incentives not to adopt beneficial AI because the liability is not explicitly benchmarked human performance level safety. AI Act Part 1, Section 5.1 examines bias. The bias definition suggests that any bias would be prohibited. AI systems will almost surely be imperfect because they're likely to be trained on imperfect and biased human decisions. Therefore, this definition of biased output incentivizes the continued use of biased human decision-making processes over potentially less biased but auditable AI-supported decisions. AI Act Part 2, Section 39A examines physical and psychological harm, physical damage. As with bias, the benchmark seems to be perfection. For example, autonomous vehicles will almost surely cause serious physical harm and substantial property damage because vehicles are dangerous. If the autonomous vehicle system, however, generates much less harm than the current human driving systems, then it will be beneficial to enable their adoption. Fifth comment on the AI and Data Act is that the definition of an AI system in AI Act Part 1, Section 3 is the use of a genetic algorithm, a neural network, other technique in order to generate content or make decisions, recommendations, or predictions. This definition is overly broad. It includes regression analysis and could even be interpreted to include the calculation of averages. For example, if an employer receives thousands of applications for a job, calculates the average score on some standardized test, and uses that score to autonomously select above average applications to be sent to a human resource worker for further examination, that scoring rule would be an AI system, as I understand it, on the current definition. I have two specific comments about the Consumer Privacy Protection Act. First, the purpose of the Act in Section 5 clearly lays out the often competing goals of protecting privacy while facilitating economic activity. While I do understand the wishful thinking that there would be no trade-offs between privacy and innovation, research has consistently documented such trade-offs. Privacy is not free, but it is valuable. Individuals care about their privacy. In privacy, this Act will require on legal expertise for interpretation. Such expertise is readily available for large established companies, but onerous for small businesses and startups. In implementation by the Commissioner, some direction to reduce any unnecessary burden on small businesses and startups would be constructive. Section 15.5 makes the cost of an audit payable by the person audited, even if the Privacy Commissioner does not bring a successful case. This creates a large burden on small and new businesses if they get audited unnecessarily. To conclude, while I have specific suggestions to clarify the language of the Act, in my view, Bill C-27 is a careful attempt to ensure that Canadians benefit from AI and related data-focused technologies while protecting privacy and reducing the potential of these technologies to harm individuals. Thank you for this opportunity to discuss my research, and I look forward to hearing your questions.
Thank you very much. I'll now yield the floor to Madame Gordon.
Ms. Gordon.
For the invitation to appear before this committee for its important review of Bill C-27. I'm a privacy lawyer and consultant based in Toronto. Having worked in the privacy field for over 15 years while raising 3 sons, I have a passion for children's privacy and will focus my remarks on this area today. My interest in privacy law was sparked as a law student down the street at the University of Ottawa when I did research with Professor Michael Geist and the late Professor Ian Kerr at the time when PIPEDA was a new bill being debated similarly to how we are today. When Professor Geist appeared here a few weeks ago, he reflected on his first appearance before a committee to discuss PIPEDA, noting that it is important to get it right rather than to get it fast. When Professor Kerr appeared in 2017 to discuss PIPEDA reform, he stated that at the time, the dominant metaphor was George Orwell's 1984, Big Brother is watching you, noting that technological developments in the years since PIPEDA go well beyond watching. Both Professors Geist and Kerr were right, especially in the context of children's privacy. Given that children are inundated with emerging technologies well beyond Orwell's 1984, from AI tools to ed tech to virtual reality to our current reality of watching war and its accompanying hatred unfold on social media, it is more important than ever to get it right when it comes to children's privacy. When Bill C-11 was introduced in late 2020, it didn't address children at all. As I argued in a Policy Options article in 2021, this was a missed opportunity, given that the amount of online activity for children was at an all-time high during the pandemic. I commend the legislators for addressing children's privacy in Bill C-27 by stating that information of minors is considered to be sensitive, and by including language that could provide minors with a more direct route to delete their personal information, otherwise known as the right to be forgotten. I also understand that Minister Champagne proposes further amendments to include stronger protections for minors. However, as the first witness stated, I think there is more that the law can do to get it right for children's privacy. I will focus on 2 points. First, creating clear definitions, and second, looking to leading jurisdictions for guidance. First, the law should define the terms minor and sensitive. Without these definitions, businesses who already have the upper hand in this law are left to decide what is sensitive and appropriate for minors. The CPPA should follow the lead of other leading privacy laws. The California Consumer Privacy Act, the US COPPA, the EU's GDPR, and Quebec's Law 25 all establish a minimum age for consent ranging from 13 to 16. Further, the law should explicitly define the term sensitive. The current wording recognizes that minors' data is sensitive, which means that other provisions in the statute have to interpret the treatment of sensitive information through a contextual analysis. whether it be for safeguarding, consent, or retention. Similarly to Quebec's Law 25, the law should define sensitive and provide non-exhaustive examples of sensitive data so that businesses, regulators, and courts will have more guidance in applying the legislative framework. Second, I recommend that you consider revising the law as an amendment or regulation in order to align the CPPA with leading jurisdictions, namely the age-appropriate design code legislation in the UK and California. Both of these demonstrate a more prescriptive approach to regulating the personal information of children. The California Kids Code requires businesses to prioritize the privacy of children by default and in the design of their products. For example, default settings on apps and platforms for users under 18 must be set to the highest privacy level. This is something that could be considered in the CPPA as well. Further, the California Code establishes a level of fiduciary care for platforms, such that if a conflict of interest arises between what is best for the platform and what is best for a user under 18, the children's best interest must come first. This is consistent with the recommendation of former Commissioner Terrain and others in these hearings about including language around the best interest of the child into the legislation. The CPPA should contemplate requirements for how businesses use children's data, considering the child's best interest. For example, use of children's data could be limited to those actions necessary to provide an age-appropriate service. As I argued in my Policy Options article in January 2023, we need a collaborative approach that includes lawmakers and policymakers from all levels of government, coordination with global privacy laws, engagement with parents, and coordination with educators. For this approach to work, the law needs to strike the balance between privacy and innovation. We want laws that are flexible enough to last so that technology can evolve, new businesses' ideas can succeed, and children can be innovators while growing up in a world that recognizes their special needs and rights. Thank you very much.
Merci beaucoup. Je passerai maintenant.
Thank you very much. I now yield the floor to Mr. Guima. Ladies and gentlemen of the committee, Chair, thank you for having invited me to comment on Bill C-27. I will testify in English today, but I will be pleased to answer your questions in either language.
Cybersecurity and Data Protection Group at Gowling WLG. I'm a practicing lawyer called to the bars of Quebec and Paris. My evidence today represents my own view, and I'm here as an individual, not representing my law firm, clients, or any third parties. Much of my legal career has focused on comparative analysis of legal regime across the globe, advising clients on their compliance obligation in the jurisdiction where I'm qualified to practice. Bill C-27 presents a tremendous opportunity to modernize Canada's federal privacy regime. It is possible and indeed essential that Canada protects the right and interest of the public while facilitating competition, investment, and ambitious innovation. Many of the proposals in the bill are highly impactful, but I will focus today my comments on the Consumer Privacy Protection Act and two areas in particular that I consider to be of great importance. First, Quebec's Law 25 learnings. The majority of the provision under Law 25 came into force in September of 2023. Over the last summer, Gowling WLG, in collaboration with the Interactive Advertising Bureau of Canada, conducted a readiness survey of over 100 organizations regarding this new law. And the results of the survey were clear. Industry was ill prepared for such an implementation. Specifically, 69% of the respondents expressed a need for greater clarity, and 52% indicated that they lacked sufficient resources. This also highlights that the compliance burden for SMEs is especially high. There are four specific learnings from Law 25 that I wish to highlight today. First, Bill C-27 should not exceed standards set by the EU General Data Protection Regulation. For example, legitimate interest is a flexible legal basis for processing, but must always be justified and documented in a separate assessment. Under the GDPR and under other global laws, a similar standard could apply under Bill C-27. Second, Bill C-27 should not rely on future regulation to substantiate its requirement. This is a recipe for delays and uncertainty. For example, in Quebec, anonymization is currently regarded by the regulator as impossible because the regulations are not yet in place. Third, BLC 27's timeline for implementation should be sufficiently long. Based on experience from Law 25, implementation should be at least 36 months after the bill becomes law. And finally, BLC 27 should be aligned with Law 25 on key concepts, including around legal basis for processing data and legitimate business exception. This is especially important when it comes to children's privacy. I'm a father of 2 young children, so protecting children in the digital economy is important to me personally, and it's a subject that I engage with regularly in the course of my work. I believe amendments to BLC 27 are necessary to ensure that minors' data is reasonably, meaningfully, and consistently protected. I wish to highlight 4 key topics for consideration. First, as opposed to the GDPR, BLC 27 lacks a threshold for determining when services are intended to target children. Practically, organizations will not be able to remain age blind and will therefore have to ask the age of user each time they engage with them, to the potential detriment of user privacy interest and data minimization. Alternative legal basis for processing should be available depending on the maturity process of the individual. Specifically, legal capacity should be a baseline for assessing legitimate basis as opposed to the age of majority alone. The process for collecting parental consent can be extremely complicated. BLC 27 should set a specific age at which parental consent is required. Under 13 years of age seems the most reasonable standard. And finally, the concept of the best interest of the child should be positioned as a key determinant of how minors' personal information should be treated, rather than relying primarily on the concept of express consent. With the chair's permission, I would be pleased to submit a copy of the survey report for the committee consideration, as well as a short written brief in French and English on the issues I've addressed in my opening remarks. I wish to thank Michael Walsh for his assistance in preparing this material. Thank you. I look forward to answering this committee's question.
Merci beaucoup, Monsieur Guillemin. Et finalement, je passerai la...
Thank you very much, Mr. Guillemin. And finally, I recognize Mr. Arbuckle. I'm very happy to have been invited to participate in the House of Commons Technology Committee's work on Bill C-67. I look forward to answering your questions on issues related to privacy and artificial intelligence services and technologies. Although my presentation will be in English, I'll be happy to answer questions in either English or French.
Je suis Luc Arbuckle. Je suis méthodologue.
Company employing over 100 privacy experts. My role at Privacy Analytics is to ensure that our company and our global clients are aligned on the practical applications of privacy-enhancing technologies and to inform our practices based on current guidance and emerging methods. I also provide guidance on the practice and risks from applying artificial intelligence in real-life applications. My role has been largely informed by my time as Director of Technology Analysis at the Office of the Privacy Commissioner of Canada, when I also drafted guidance on anonymization for the office. Privacy Analytics operates as an independent entity within the global IQVIA group of companies, so that we can provide both IQVIA and our global clients with services and technology for the safe and responsible use and sharing of data. The Privacy Analytics platform has been deployed globally to protect the privacy of close to 1 billion patients. For example, our software has enabled safe research that improves cancer outcomes for patients through the European Oncology Evidence Network and the American Society of Clinical Oncology's Cancer Link. We have also worked with multiple government agencies in Canada, Europe, the United States, and globally to implement safe data access models that enable faster data access, promote research and innovation, and implement data-driven decision-making. It is against this backdrop that I wish to provide comments today. In particular, I will provide a perspective on the importance of health data and analytics for Canadians. Healthcare-related research is increasingly driven by analyses that draw from real-world evidence to reveal the effectiveness of treatments beyond the clinical trial phase. The success of that approach is predicated on the availability of the necessary data from various sources within the relevant healthcare system and on the ability to analyze data across different healthcare systems. For Canada to take part in this new frontier of healthcare research, it is important that we prioritize a responsible data access model that strikes the appropriate balance between privacy and having useful data for the intended purposes. We also need a data protection framework that allows for efficient and effective data sharing and collaboration with stakeholders from all over the world, including the United States and Europe. As COVID-19 has shown, it is crucial that Canada stays active and competitive in life sciences. This means developing an approach to privacy that supports local research and innovation and allows healthcare research in Canada to align with efforts outside the country. I will only summarize 3 recommendations in my introductory remarks and invite you to consult IQVIA's full-length comment document on Bill C-27 for additional comments and details. Recommendation 1. Consider a reasonableness component within the definition of anonymize. The use of anonymized data in healthcare analytics is a key element in the research and innovation activities that help drive Canada's healthcare future. Canada's diverse group of healthcare stakeholders use anonymized information to identify inefficiencies and allocate resources more effectively, to speed up the development and approval of new treatments, and to understand the needs of patients and healthcare professionals. Such uses of anonymized information contribute to better health outcomes and other notable benefits. Including a reasonableness component within the bill's definition of anonymization would align better to the other Canadian frameworks, such as Quebec Law 25 and Ontario PHIPA. A reasonableness approach would also align better to the growing consensus in the academic and technical literature regarding the need for a realistic framing of risk in describing anonymized information. Take, for example, the risk-based international standard for an anonymization framework, technically known as ISO 27559. This technical standard was developed by experts from around the world and is consistent with the draft guidance I produced while at the OPC. Recommendation 2, consider expanding the consent exception for socially beneficial purposes to include private sector organizations. A more principled approach would be to enable responsible data sharing between a broader range of actors while also mandating adequate oversight and data protection best practices. Recommendation 3, consider a consent exception for external research, analysis, and development purposes. Removing the internal qualifier would be a more beneficial approach as it aligns with existing guidance and would enable a more useful model for healthcare research and innovation. With that, I would like to thank the committee again for their time and for the opportunity to speak with you today. I strongly believe that it is possible to safely and responsibly use and share data in ways that protect privacy while driving innovation for the benefit of Canadians. I look forward to the continued discussions. Je me tiens à votre écoute pour la suite des discussions. Merci beaucoup de votre attention.
I'm available to answer your questions.
Much to all of you, and to start the discussion, I'll now yield the floor to Mr. Viss for 6 minutes.
Thank you, Chair. Ms. Gordon, thank you so much for your comments, and thank you all of the testimony today was just amazing. Thank you. Mrs. Gordon, you mentioned your 3 kids, and that's sort of what's driving me with my 3 children as well, and the work we're doing to make sure that this bill is done right and that children's privacy is protected. I've asked other witnesses questions on Section 9 of the bill, privacy management programs. In some cases, what I'm hearing from your testimony is that in addition to management programs, especially in relationship to children, we need to be prescriptive in some aspects of the bill. Would you support amendments to Section 9 or other additions to the legislation that were prescriptive specifically in the case of children? Maybe Section 9 in its current form could apply broadly to privacy concerns and providing protections and making sure that businesses are providing those protections in the products they're producing. But what do we need to do specifically in respect to privacy management programs as it relates to children?
So as I said in my remarks, I do believe that the law can be more prescriptive in terms of making sure we get it right for children. That is something that we've seen in other jurisdictions. They've done it separately in a different law with a specific children's code. I think that we can make certain amendments to the law or have a separate regulation. I mean, part of the problem with the regulation, as Mr. Goulman said, is that it takes forever sometimes to get there and to get that guidance. So it's not always the best to leave it to regulation, but that is one way of doing it. But I do believe that there are ways of adding amendments and making it more prescriptive so that we can get it right in the law.
Instead of privacy management programs, then, would you support privacy by design, requiring businesses to create products that are designed to have the privacy safe for children as the first and foremost priority?
I don't think that they're 2 separate comments. I think that you can have privacy by design in a privacy management program.
Thank you. That's what I was looking for, actually.
Okay.
That's very helpful. Sorry, I have lots of notes today.
Je propose par respect qu'on arrête le chrono.
Out of respect, could we stop the clock?
How would you define sensitive information?
So I don't have a specific definition, but I do believe that we should be able to give a exhaustive list of examples, similar to how we've done in Law 25 in Quebec.
Can you give us some examples of a non-exhaustive list, or what would be included in that?
Sure. So some examples that we've seen are biometric data, health data, financial data, and children's data. So those are the ones off the top of my head, but I could certainly submit some more examples.
Is there a risk if we apply a non-exhaustive list of leaving future technologies out of a list and having companies being able to break the spirit of the law by not having a certain form of like privacy or sensitive information not included?
I mean, that's definitely a risk, but I don't think that's a reason to not do it right now. PIPEDA has worked really well for 20 years, so I think that, there's always going to be modernization to laws, but I think it's important to try to get that list now, and with the acknowledgement that there is the possibility of updating it as things change.
Okay. The UK model for privacy includes, like I believe in California, certain thresholds. I believe the spirit of the law implies that children at different stages are able to make different types of decisions. How would you see that type of prescriptive language included in our Bill C-27 before us today?
I don't have any specific comments right now on prescriptive language. Again, that's something I'd have to go back to. I know that's something that my colleague, Mr. Gilman, also referred to, so maybe he has comments on that.
Would you like to comment, sir?
Yeah. So I would like to take a look at what is being done in Europe at the moment. And of course, the GDPR has been a big change for them, and children's privacy was a key consideration. Because it's extremely difficult to provide prescriptive requirements, they instead relied heavily on the notion of best interest of the child. And this is working. And the reason why is because it's not a free pass just saying, you know what, we talk about children, but there's nothing to be done. Organization needs to have a documentation regarding what they are doing. And the second aspect I would like to highlight is just, of course, especially being a lawyer, I like, clear definition. But the notion of evolving concepts, such as the best interest of the child, is important as well in laws, as opposed to very clear-cut concepts such as, for instance, express consent, where essentially every time we would need to have express consent, regardless as to whether it's a teenager or under 13 years old. So I think this is what we are seeing across the world, because many parliaments understand that we are living in a world constantly evolving, and we need future-proof concept. And the best interest of the child is not moot. It's a good concept, I believe. At least it's my personal opinion.
Okay. Mr. Chair, how much time do I have left?
3 seconds.
I'm good, thank you.
Thank you. I'll now turn to MP Sorbara for 6 minutes.
Thank you, Chair, and thank you to all the witnesses for your testimony on a very important piece of legislation. If I can go to Mr. Goldfarb for first questioning. Mr. Goldfarb, you mentioned in your remarks, if I can just go back to them, that Canada is a leader in AI research and that AI data-focused tools are promising for economic growth, but obviously they must be utilized. And in that vein, you published an article in September 2023 on the economics of digital privacy. I was wondering if you can elaborate in terms of how Bill C-27 would impact innovation and thus productivity and thus our standard of living through Canadian businesses and the economy, please.
Okay, thank you for the question. So there's two key forces at play here. The first force is anytime you regulate and companies and startups, especially in small businesses, are going to require lawyers in order to do business, that's going to slow down what they're able to do. That's on the one side. On the other side, if there is no legislation in place, then potential customers of those companies aren't going to trust the companies. And so even though the the need to get legal advice and essentially, which apologies to the lawyers in the room, is a real barrier for small businesses and startups. You do need legislation so that people can trust the companies that they interact with. And so, in my view, this bill balances those two very well, like with some minor exceptions that I mentioned, but it protects against the most severe privacy harms, so that we will have more trust in what organizations do with data. That will, in turn, and the set of regulations as described. Yes, it is a bill that runs dozens and dozens of pages. You'll need expertise, but it is not so onerous that I would expect that small businesses and startups that have a big opportunity with AI will have to shut it down. So in my view, on balance, this will position Canada well going forward for our ability to commercialize AI.
And going down that vein, in terms of when we compare pieces of legislation in different jurisdictions, how would you characterize the framework in Europe, the GPDR, versus what's contained in Bill C-27, with relevance to the impact on innovation and the economy?
Okay, we have plenty of evidence that the GDPR, when and where enforced, reduced innovation, hurt the European software industry relative to the American software industry, and helped the largest companies, particularly in advertising technology, do better and better. So there were real costs to the protection of privacy that happened through the GDPR. When I look at how this bill was drafted, I think in protecting privacy and thinking about and addressing the potential harms for AI, to me, it's clear that it was drafted with an eye toward the need for startups and small businesses to compete on a level playing field with the largest companies. And so, in my view, this bill is more innovation friendly, particularly for small businesses and startups compared to the GDPR.
Okay. No, it's obviously wonderful. Well, it's good to hear that in terms of how the law impacts innovation and productivity, because we know innovation is a very large piece of what really AI is, and the impact it will have on our economy and standard of living and our really daily way of life. To Luke, obviously, my understanding is you're a private sector firm, is that correct? And that you're a privacy expert. One thing that, when I jotted down a few notes from your presentation or your discussion, in terms of you commented about the reasonableness approach, and like that, in a realistic framework of risk, when it comes to anonymous information. I'm mispronouncing that. I apologize. Can you elaborate on that to non-privacy experts, non-AI experts such as ourselves, who are grasping the information that's put in front of us in this bill, and how important this is to everyday Canadians going forward, realistically? Can you elaborate on what you meant there and contextualize, please?
Yeah, the word contextual is important here as well, because that's kind of how we want to look at anonymization. We want to look at where we're using this information. So when Statistics Canada produces statistics or data that they make publicly available, the risks are very high because they're on the internet. Anyone can access them. But they also take data and they put it in a research data center. It's disconnected from the internet. You have controls regarding who has access to the data, how they can use the data, what they can come in or out of the environment with. The risks are much lower. So it's contextual in that sense. So the idea of a reasonableness standard is bringing that contextual piece to it. So when we look at international standards, for example, they're primarily very scientifically driven by risks, and risks are never zero. And so by looking at it in this contextual way, we can manage the threats and use other tools besides just aggregating and creating, means, like as was mentioned earlier. We can do things a little more sophisticated, and we can have strong environments that control that information.
Prior entering in this privileged and honored job that we get to do, I worked in the private sector for a very long time, very large organization in the financial services industry. Your company's use and compliance with PIPEDA, how would you explain that?
How we're complying with PIPEDA?
Yes.
The technology that we use, both the sophistication of it is compliant in the sense of we look at the best practices that exist, we look at international standards, we look at guidance that is being produced, and we ensure that the anonymization that we do meets those standards. So we have guidance in Ontario, for example. We have the law itself, for example, in Quebec. We have a variety of jurisprudence, which is not my area, of course, but we look at the best practices in terms of technology. We monitor the literature, the landscape of what's happening, and we modify accordingly.
How much time do you have? That's it? Okay. Thank you very much.
We might have some time at the end. Je passerai la parole à Monsieur Lemire.
And now I yield the floor to Mr. Lemire. Thank you, Chair, and thank you to all of our witnesses. I think that our meeting is of the highest quality today, and I really appreciate your being here. Mr. Guillemin, I'll begin with you, somewhat picking up on what my colleague Mr. Sorbara said. The Quebec Law 25, and this is on the letter that we have published on the committee's website, the Law 25 in Quebec, there is some concern that if it sets standards which are lesser, the current bill is less demanding than the Quebec one, this will create an imbalance regarding investment in Quebec. What do you think that C27 will do to the investment and innovation landscape of Quebec? Currently, C27 is quite alignable with Quebec Law 25 on a number of concepts. I'd even say that the Quebec legislation is more strict than C27. And let me say more, that Law 25 is one of the strictest in the world at present. This must be said. In my practice, I work with clients who are international, out of the USA, Europe, or Latin America. And right now they're looking at Law 25 and saying, whoa, this is one of the most complex to apply and to respect, and not for the better necessarily. So my position here today, and I'm speaking most sincerely, is that interoperability between the two, yes, we've got it. But that said, there are things we can learn from Law 25, and I am allowing myself to quote the PIPEDA. I think that's a very interesting benchmark standard for C27. It's really a position that's been taken. Many good things in C27. Keep in mind that at the legislative level, it's really a big change. C27 is changing current legislation. It's as though you're taking an older legislation, back to 94, and bringing it up to date. But here you've got unity. It's an overall approach. So I would say rather that it is possible that Law 25, it may not be the best benchmark. That's my humble position on that. Thank you very much for that answer. What clauses or amendments could be made or brought to Law C27 to improve the interoperability that we've just discussed? And of course, I'm very sensitive to ensuring that innovation and investment be supported. Is there any danger? Could we be blocking investment and innovation in Quebec? Well, of course, you know that in matters of privacy, consent is a benchmark, and everything goes through consent, and that's how you build legislation around this, C27 as well as Law 25. What's different in Quebec right now, and it is a very different approach they've taken from the rest of Canada. They've tried to say in their legislation, and this has been certainly confirmed in recent comments on this, that with regard to private information, you needn't receive permission inasmuch as a colleague is allowing for the communication of personal information. For example, if you go on the internet, right now you sort of get attacked, if you wish, or presented with a number of different methods for consent, same for children. And your capacity to manage that as an adult isn't of the best. You know, I don't read everything myself. But in Quebec, they took a different approach. They said, we won't ask people to click their consent. We will just provide them with information, and then they could go on with the process. So this transparency approach used in Quebec, as well as at the federal level right now, the way the legislation is written, seems to indicate that each time you would have to take a specific action in such situations. I think that's an important difference. Once again, it's not a bad thing. It's just that it's being done differently. A little more transparency, a little more control is being given rather than forcing people to consent a little bit without knowing what they're consenting to. Another quick question regarding the timeline before C27 becomes law. Should we act quickly? What would be wrong with taking our time on this in the parliamentary context that we're in, and also how long it would take to actually apply this law, taking that into consideration too. All right, this federal legislation is quality material, so I don't think that there's any rush to go ahead. There are already some quite good approaches out there legislatively that ensure that businesses are not just doing whatever they want. That said, C27 is very ambitious, and here with regard to the privacy protection aspect of it. So it may take time to adjust procedures and processes once it becomes law. Keep in mind that businesses, as of last September, have been considering C27 and trying to prepare to adapt to it, and it's a lot of work for them. I think it would be a good idea to avoid duplication of resources, creating a kind of fatigue among businesses who will start to wonder exactly what the final message is. So I think that it would be important to allow for an adaptation period, but you don't have to work that quickly. And then how about our alignment with the European General Data Protection Regulations? I think that C27 is analysis, that may take years. By the way, let me be clear. There has been a decision made, and the European Commission has decided that Canada is a good partner to work with. But I think that C27 is a good project when it comes to trying to align with the GDPR adopted in the EU. There are slightly different approaches on sensitive data, for example, but I do think that C27 is heading in the right direction, besides, of course, setting aside certain issues about anonymization and legal funds to manage privacy information. Thank you, Mr. Lemire. Mr. Massey.
For being here, and maybe I'll go across the board here. With the Americans, Biden's executive order, that basically gave, basically the administration from the top up more control and ability. It basically removes Congress in many respects from making decisions, and the executive order is almost like an order in council here. We're fortunate to be in Washington with our clerk was there, our analyst, was there as well too. We're clarifying that. It was an interesting point that we didn't realize to the extent that it has been removed from the halls of Congress and to some degree of Senate. So wondering what your position is with regards to how we deal with the United States executive order coming from the administration, because it really will be a top-down approach that they're going to have, and how do we actually have any type of consistency with that of our country as we go through these hearings here. So Madame Gordon, I don't know if you want to start and then go across the table here.
I have to think about that for a minute, so
Okay.
one of my colleagues can start.
Yeah.
I'm going to be very blunt. I'm not sure I'm equipped to respond to your question.
Okay. Yeah.
It's an interesting question. I think, we're talking about the AI, the executive order on artificial intelligence. Yes, it's an interesting question.
Sorry, I should have been more specific.
No,
yes.
it's okay. It's okay. I just wanted to check. There may be another one. You never know.
I just popped.
It's interesting. There's a lot of activity. There's a lot of work in the U.S. The National Institute of Standards and Technology, for example, has put together really good work on AI risk frameworks and how to manage. We've heard a lot of good things in the executive order. So from a technology perspective, I think it's kind of exciting to see, the talk of safe, trustworthy, responsible AI. And so regardless of the procedure, that I can't really speak to, but I do think it's exciting to at least see there's a big push. Canada is known for privacy by design, for example. So, we have an opportunity as well to kind of take the lead and do things in AI. As it was mentioned earlier, we have researchers that have done tremendous work really bringing this forward. So regardless of the procedure of how it was done, I do think it's interesting that they're pushing it so much.
Yeah, the procedure, and I don't know if you don't have comments, it's okay, but if you do, the procedure, the reason I outline that is that it's going to come right from, the president now, and actually kind of bypasses to some degree the oversight of Congress and the Senate. So that was kind of the way that they approach, almost hand over the elements to the president, whereas we're still in a committee here. And we still have to go through legislative process, and then we have to then send this to the bill to the Senate, and then we have to get it done. And then at the same time, we don't know exactly if we're going to be something consistent with the United States. We have to somehow figure that out. So it's almost like if we wanted to have something similar or comparable, we almost need a treaty in some respects from this. So I guess what I'm worried about, and of course we want our sovereignty, but is if we are significantly different to the United States, does it affect our capabilities to retain investment and AI here, or does it put us in a better position potentially? I'm just wondering what thoughts are on that, because we could have up two different models in North America on how to deal with AI. Any thoughts on that?
I think a general thought would be that I don't see it as a particular problem, because that's what we see, having seen many laws across the world, it's never unified. I think this is something impossible. Even in Canada, we've got private sector laws in BC, in Alberta, in Quebec, and the federal statute. At the moment, they are not unified. They are different. What is important is interoperability, the ability to talk between the laws. And I think this is something we should seek, as opposed to having exactly the copy carbon potentially of what is being done in the US, or the same would apply with Europe. I think it's just looking at what they are doing and just making sure our concepts are flexible enough to essentially talk with the potential legal regime that is being adopted in the US.
Okay, that's it's a good distinction. What I worry about coming from my world is that we had for years two different sets of bumpers on cars, and then so it stopped the ability to talk and trade, and you actually had some companies doing duplicate stuff. And so I don't know. I don't know enough about this as to whether or not it impedes, because unlike the European Union in many respects, we have a lot of North American partners and subsidies back and forth. So I'm just trying to figure that out. Real quickly, how much time do I have, Mr. Chair? Okay, just quickly. Anybody have any on the issue over the Privacy Commission Commissioner's recommendations? Are you in favor of the Privacy Commissioner's recommendations or opposed to them? Is there anything that glares out there? Does anybody have any comments on that?
Out of the 15 recommendations?
Yes, yeah.
Okay, if I can opine on one aspect, there are some interesting ideas. I think there's a will to add accountability obligation on companies. I think this is something that is being proposed. I have some caveats in this regard, having seen what is being seen in Quebec at the moment, especially for small and medium-sized companies, where essentially they are struggling very much to essentially have accountability documentation for everything. So it could be a good idea to the extent there are thresholds. And I think this is the key aspect in this kind of laws, having the notion and the principle, but not forgetting the exception and the thresholds. So I think this is something, my top potential concern with their recommendation.
Anything else? Thank you, Mr. Chair.
Okay. Just to add to that, I think it's important to recognize there are trade-offs here. As we make the privacy rules on this legislation stricter, in many cases, we're going to get less innovation, particularly from startups and small business. The big is going to be fine, but the startups and small businesses will have a harder time as it gets more difficult for them to collect and organize data. And so, to the extent that those recommendations are accepted, keeping an eye on making sure that we don't overly burden those small businesses and startups is important.
Mr. Beauvais?
To quickly respond to Mr. Massey's question about the executive order, I would note that insofar as you're able to put things into secondary or delegated legislation, you would provide an opportunity for some type of harmonization, but that's a tricky question in terms of balancing what should be in primary legislation versus secondary legislation. Thanks.
Thank you very much. MP Williams, the floor is yours.
Thank you, Mr. Chair. So I want to stay in the same vein. I think this is a great discussion. We obviously believe in privacy as a fundamental right, but at the same time, businesses have to be able to collect and use data. And I guess we're in a unique situation right now with C27 because the GDPR has just sort of come into place with some of their, I'm going to hate to call it red tape, but the processes in which businesses, small businesses and otherwise, have to follow those rules. And I think what we're trying to look for are good amendments in this bill that obviously make sure that privacy is held as a fundamental human right, but also protect businesses, the overburden, the policies and procedures that are going to weigh on businesses' ability to do business, as well as to collect and use data for good. So I'm going to start with Ms. Gordon. What can we do in this bill? What have we learned from the GDPR to ensure that that collection, the consent models, are as easy for businesses while also protecting privacy?
I mean, that's a really good question. In general, I support the new exceptions to consent in Bill C-27 that are similar, slightly different from the GDPR. Agree that the application of the legitimate interest exception, whether it be as a standalone right or as an exception to implied consent, will help a contextual analysis and will help, nurture innovation and allow for a difference between, how organizations look at their programs and look at accountability and transparency.
Would you support amending the bill to exempt businesses of a certain size from filing requirements?
Again, that's something I'm not entirely qualified to comment on right now, but
yes. So thank you. So Mr. Gulman, and the first question too, on that question specific, but also on the burden of business.
I want to start by saying something which it sounds like a paradox, but I believe it is true. More prescriptive requirement will not lead necessarily to more protection of personal information. And I think it needs to be heard in a sense that it's not because we add a lot of burden on organization, then it's going to be better for the public. And I want to start with this statement. That said, in terms of, and I will give you an example. When we hear the word legitimate interest, the perception may be just to say, well, it's a free pass. You do whatever you want. There's no consent, you do whatever you want. But the fact is, in the GDPR, there's always a documentation. And more than this, to your second question, for small and medium-sized company, I don't think it makes sense to essentially, based on the number of employees, have different obligations. However, what matters is the sensitivity of the information, the volume of the data. And these should be, from my perspective, the triggers to essentially say, well, you need to have more documentation in place or explain what you're doing. Those should be, to me, the triggers. This is my humble opinion. And again, it means that I don't think we should be afraid of using some terms. And also, exception doesn't mean that there's nothing in place. As a matter of fact, I think in the back end, that's what I'm seeing. There's a lot of documentation in this regard.
So I guess to ask that specific question again, would you support amending the bill to exempt businesses of a certain size from filling? No. So you'd require all businesses to fill that documentation out?
To the extent we are adding sufficient triggers based on the types of information. Because it's been raised, this question, as part of Law 25. Clearly, the question was, what do we do for a company, let's say a dépanneur à la tuque, essentially he has some personal information, what do we do with this? And the fact is, the dépanneur at la tuque potentially will have really non-sensitive personal information, and as such, should not potentially need to have a privacy officer, and that makes sense. However, let's say we have a growing company with 20 people, doing building interesting AI model and with biometric data or health information, I think it would make sense to potentially having some obligation. Again, this needs to be proportional, but I want to give my opinion. I don't think a number of employees makes sense, or even, the revenue is not a good threshold from my perspective. And I don't have the proper translation of the dépanneur de la Tuque, but...
Letuc's Corner Store.
It's le mien.
Dépanneur in François-Philippe Champagne's area of the world.
Other witnesses, Mr. Chair, would you like to weigh in, Mr. Goldfarb?
Yes, just when you create thresholds based on the number of employees, it creates incentives for businesses to stay small. And so to the extent that there is a desire to add additional burdens on businesses, recognizing the trade-off, think if it's about the number of employees, because what you're telling businesses is we don't want them to grow.
Mr. Arbuckle, anything to add?
I'm very supportive of all the comments that have been made. We've had this debate when I was at the OPC. We did a public consultation, and it actually came up as the startup company, the AI startup, processing terabytes of data. It's not about the size; it's about the amount of data and what kind of data. To your earlier question as well, I'll just add some of the comments that I made earlier about consent exceptions. I think there is an opportunity to align more closely with GDPR. In the sense of making it available to a broader range of organizations, small, large, et cetera. Dealing with health data, for example, I've seen this. Working across Canada, you have some small, vulnerable population groups. They can't anonymize that information. It's too small a population. So how do they bring that data together? How do we bring healthcare data together? Well, part of it is through some of these current provisions, I guess you'd call them, where there's a de-identification. So, you take out the person's name and you put a pseudonym, but we can still link and then produce really interesting, important statistics. So that's the one thing I just want to bring forward.
Monsieur Beauvais.
It's the point about record-keeping obligations is interesting. To my knowledge, the GDPR's only kind of olive branch that they hand to small and medium enterprises is indeed concerning the record-keeping obligations. I would note that in the case of a children's code, which Ms. Gordon and I have spoken about, that can actually be very useful for helping businesses because it provides them with, in a way, a kind of starter manual for thinking through how they should design their products and services that are directed to children. So you can raise protections while also being clear and helping businesses out in compliance.
Thank you. Mr. Turnbull, the floor is yours.
Wonderful, Chair, and what a nice surprise it is to have a meeting with such great witnesses without the Conservatives moving a motion to disrupt the meeting. So it's really nice that we get to have you here today. And so maybe, Mr. Goldfarb, we'll start with you. I know you mentioned an overly broad definition of AI, and you cited some examples like regression analysis and some others that might sort of be captured within the definition of AI currently. And I'm wondering, how you might narrow the definition. So I'm not sure if you have specific suggestions on wording or amendments, but I'd be interested to hear your thoughts on that.
Absolutely. So in my speaking notes, I have a footnote, so I'll just read that, which is the use of a genetic algorithm, neural network, machine learning, other AI in order to generate content or make decisions. So the current definition is any prediction model. An average and regression is a prediction model. The definition of an AI technique will evolve over time. And so that what the use of another AI technique does is it allows for the flexibility of the technology to change over time, but it doesn't make us start regulating technologies that have been around for centuries, like statistical technologies.
Okay, thank you. And I know we've also had a sort of a running theme here about perhaps the compliance burden being fairly high on SMEs. And Mr. Goldfarb, you talked about a trade-off and or trade-offs. I think it was in the plural. You said privacy is not free, but Canadians care about it. I think many of us probably agree with those sentiments. What I want to understand is how do we reduce that burden without going too far? Like, how do we, because I think I've been thinking about this as a balancing act, like many pieces of legislation are, between different interest groups. And there's some people that say, the fundamental right to privacy should sort of supervene everything. And it seems like we could go too far down that road a little bit and really stifle innovation and also cause undue sort of compliance burden on small to medium-sized enterprises. So I know you spoke to that. I wondered if you could make any suggestions on how to reduce that burden specifically. Thanks.
For sure. So my starting point is, I think this legislation already is at a good starting point. Okay, so where we are right now is good, and my concern on the trade-offs would be if we're adding additional things. That said, there are two pieces that I think are particularly important. That which is just some sort of the first one is some recognition by the commissioner of the burden on small and startup businesses, and especially right now the cost is by the person audited, even if the commissioner finds nothing. And that strikes me as very risky. If we have a commissioner who decides for whatever reason that a particular company, especially a small company or a startup, deserves an audit, and they go through that process for the startups that we work with at the Creative Destruction Lab, that may very well kill the company. And so some reasonable expenses, in my view, should be covered by the commissioner or by the government when the audit shows no evidence of a contradiction of sections 6 to 12.
Okay, that's interesting. I hadn't thought of that before, but I can see your point that the risk of being audited or actually being audited when it doesn't is maybe perhaps not, or is proven later to be not initially warranted, then that could be very costly if the burden is on the small to medium-sized enterprise. So I get that. Mr. Guillemin, I hope I said it right, and my French is not that great, but I try. You had also mentioned this sort of as a running theme in your opening remarks. So I'm kind of interested. You said industry was ill-prepared. You even said that the implementation time should be up to 3 years. So I'm wondering what your thoughts are on how do we get the balance right, but also reduce the burden. I wondered if you had any more thoughts that you haven't been able to share on the trade-offs there.
Yeah, so I think there's two sub-aspects from my perspective. The first aspect is the transition period. I think we should not undermine the fact that there are already processes in place, yes, with PIPEDA and potentially with Law 25, but it does take time, just to have something which is meaningful. And I'm a lawyer, so I wish I could tell you it's only a question of preparing aspect and just giving you some policies and move on. The fact is, privacy is much more than only legal professionals. And I think there is an understanding internally in any organization to understanding what is going on in terms of data flows and what do we do to protect the information we have. So that's the reason why I tend to think that 36 months is the bare minimum. And as a matter of fact, when we look around the world, that's what we are seeing. We saw with Law 25 that 24 months was not sufficient. At the moment, companies are struggling very much to even comply now with Law 25, which is into force in almost everything. The second aspect to your question regarding what do we change, and I will give you an example very simple. If we go to Section 8 of the CPPA, we do mention that an organization must designate one or more individual to be responsible for matters related to its obligation under this act. I'm going to take my example back of the dépanneur de La Tuque, the groceries of La Tuque. They have very few personal information, and their first question to me will come to me just to say, who do I appoint? Who is my privacy officer? And I think this is where it's problematic, because I'm not saying that it's not based on the size of the company. It's more the question of the volume and sensitivity of the information. The good news being that this threshold is present in BLC 27 in some disposition, and particularly when I look at the privacy management program, it's been cited, Section 9, there is a caveat depending on the sensitivity and volume of the information. So I think the key aspect would be just to look at those absolute requirements and just to say, do we add a threshold based on the volume and and sensitivity of the information. I think this could be a good exercise in the full version of the CPPA at least.
Thank you for that. That's great. Mr. Arbuckle, I have a question for you if I still have time. Following up on my colleague's, Mr. Sorbera's comments, which I thought were quite good, in terms of the reasonable component on anonymized data that you were talking about, what I wanted to understand better was what's kind of at stake. So I wondered if you could provide an example where the health outcomes would actually be potentially compromised. Because I think what you implied to me was that if you were adding that reasonable component to the clauses around anonymized data in the bill, that in fact you would allow for that contextualization and perhaps a strong protected environment, in which case you could use that data for purposes that were beneficial. So, and you spoke to health outcomes. Could you give us an example to illustrate?
Sure. I mean, we've seen it in even under other jurisdictions, but basically the best example is probably the one of small populations when you want to bring data together and produce, because basically what is anonymization? It's producing statistics. So we've heard like means and aggregates and averages and stuff. That's essentially what we want to do when we talk about anonymization. If we make the threshold such that it's a zero risk, then if I have 100 people, if I take the average age of everyone in this room, then you would say, well, it's not enough, it's not anonymized enough, but who's going to be able to identify me from the average age of this room? But that's the risk. You're going so far, you're saying, well, 100 people is not enough. That's not, we got to go to 1,000. And then suddenly you cannot generate the statistics that we currently generate for things like, in our submission we included like opioid and mental health. Right? These are examples where it would be very hard to create the granular data to see trends over time, to see among different age groups, among different provinces.
Thank you very much for that exchange. I found that very valuable. Chair, I think I'm out of time probably. Yep, thank you very much.
Thank you very much. Monsieur Lemire.
Mr. Lemire. Thank you, Chair. My question will be for Mr. Goldfarb this time. Over the last few weeks, the Bloc Québécois, while we've heard concerns about creators feeling that their copyrights aren't being protected sufficiently, very important in Quebec, where art, literature, and the arts in general really are at the core of our linguistic survival and cultural vitality. So what would be in here to protect the rights of creators, of artists?
Oh, sorry, I thought there was more coming. As from my read of the bill right now, it is not addressing AI and copyright. I think there's important trade-offs to recognize in thinking through. On the one hand, it's very important that artists and other people who create work get compensated for it. It is also important that we recognize that there has to be some aspect of fair use, just like when we ourselves read a document and then write something 2 or 3 years later, and that document might somehow be in the back of our minds as we're drafting it out. We might cite that original person, we may even not, but we don't owe them funds for copyright. And so if you, so the first response is, from my understanding, this bill does not address that. There's reasons to think that clarity will be good. Wherever we land, a lack of clarity is going to be difficult for businesses to build AI systems, and it's going to be difficult for copyright owners to get compensated for their work. So clarity is good, and as I understand it, it's not in this bill. Second, I do think it's important to recognize that some of the uses of some of the ways that copyrighted work is an input as data into the AI systems are very clearly related, to the value of the copyright. Like, if you ask it to, write a song in the style of the Tragically Hip, it will, and that's the style of Tragically Hip, and that seems related to Tragically Hip related copyright. In contrast, if you ask it to create something that rhymes, and somehow in the data set is some rhyming copyrighted work, thinking through how every single copyright owner who's written something that rhymes should be compensated will be quite a nightmare.
J'attends-tu poser une question le temps que mon collègue...
Shall I wait for my colleague to return before I put another question? All right, so how much further could we push copyright here, and could it affect cultural creativity? Could we take into account best practices elsewhere around the world to avoid having negative effects?
I was at a recent poetry reading, of all things, at an AI conference. And the poet was a poet who used AI to develop her poetry. And it was amazing and fascinating and a pleasure to listen to. That's creativity enabled by AI. That poet got to copyright her work. The other poems that were inputs into the overall database at that point did not get to benefit from the copyright of their work. And so the reason I tell that story is to recognize that for cultural creativity going forward, there's reasons to want a very open use of these AI systems, because there's incredible creativity coming out of these AI systems. Not the AI, let me be clear. One of the things I love about the bill itself is that it's so clear that humans make decisions and not machines. And so the creativity is human creativity enabled by AI systems. And in the process, though, we do need to make sure that when copyright is violated in a particular way, as in, it's clear that you're trying to mimic a particular artist's style, that gets protected.
Merci beaucoup.
Thank you very much.
Merci, Monsieur Massé.
Thank you, Mr. Massé. You have the floor, sir.
Thank you, Mr. Chair. Federal parties are not currently included in the bill. Does anybody have any feelings on that and whether the inclusion of federal parties should be part of it? We were exempted from other legislation in the past, the do not call list as one. Does anybody have any feelings on whether federal parties should actually be part of the bill, especially when it comes to the privacy commissioners and elements too? Anybody? Yep.
I agree. Other witnesses who have testified here have said that they should be included in the legislation. I agree with them and agree with their reasoning.
Yeah, and it could be, it doesn't have to be exactly the same as the business sector either. It could be done in a different type of a way. So it's not, it doesn't have to be entirely the same. But I mean, I think there is an argument that could be made that federal parties should be part of this. But at any rate,
yeah, and I would agree as well. I think my only problem, I'm a bit maybe too dry, but it's the title of the law itself, the Consumer Privacy Protection Act.
Yeah.
The notion of consumer is misleading at this stage. And I think it's something to emphasize, even though I don't disagree with the principle to potentially having federal political parties being subject to the law.
Well, yeah, well, you've been here long enough, you know that the titles of bill are often divorced from the reality of what they are. So a fair point. I'm actually complimenting, not criticizing your analysis of that. Anybody else have any thoughts on that? Our witnesses on screen?
I know Colin Bennett, amongst others who were appearing before this committee, also raised this point. In light of kind of big data political campaigning, it's very difficult, I think, to sustain a justification for why political parties should not be subject to data protection law. So I would certainly encourage their inclusion. If there are specific concerns, a balancing can take place in a way that, data protection laws frequently balance with journalistic purposes and these sorts of things. So if there are very specific concerns about campaigning and the political process and how data protection law can affect that. I think that that should be considered in a very specific manner, but certainly as a big picture item, I think that political parties should indeed be subject to data protection law.
Chair.
Merci. Monsieur Généreux, la parole est à vous.
Thank you, Mr. Généreux. You have the floor.
Monsieur le Président,
Thank you, Chair, and thank you to all our witnesses. This is highly interesting. Mr. Guillemot, I will go to you, and I'll go back to La Tuque, to the corner grocery store, the dépanneur in La Tuque. Of course, we've all understood that this dépanneur, this corner store, is in the county of the minister. Perhaps he thought that he had a private life there in La Tuque, but now, well, it's quite clear that his corner store is going public. Now, this is about small and medium-sized enterprises across Canada, of course, and we know that Canada has an economy that's shored up on these smaller businesses. So in this legislation, we are speaking to individuals, but also to entrepreneurs and to enterprises that will need to adapt to the legislation. Now, you mentioned a survey regarding Law 25 in Quebec, where about 70% of people said that they needed more information about this legislation. Do you think that you'd see pretty much the same for C27? Let me say, by the way, that consultations are good, and you do think that this is good legislation, but that's not really what we've heard from our consultations from the outset. Many have said that they hadn't been consulted. Organizations whom we've heard here as witnesses said they hadn't been consulted, and some even said that it would be a good idea. I think that one of you, Mr. Goldfarb, actually said this, that it would be a good idea to have more consultation. So my first question, do you think that it would be a good idea to have more consultation? And second, we have often been told that we should, at the outset, have separated AI from the consideration of privacy, two different aspects of this matter. So what is the potential real effect of the red tape and bureaucracy that could kind of muffle this whole project? Let me give you an answer in three parts. First, I do agree, and my humble opinion is that parts 3 and 1 and 2 are probably not at all linked to the rest. So are not necessarily linked. So that's a real issue. The part of C27 that I do like, it's really parts 1 and 2. To put it simply, that's for one. I think part 1 is a really good beginning. It's not perfect, but around flexibility of consent and so on, it's a good basis to work from. Second, going back to what I said earlier, I think there's a matter of good common sense here about this legislation, looking clearly at the obligations. If I were this lovely corner store in La Tuque, we're certainly advertising them. I'm not sure if there's more than one of them, but looking at this C27, I would ask, is this going to really help me? Is this going to change anything in my business model? Because that's the aim here, to tell enterprises, well, not just creating problems for them, not just trying to trip them up, but saying we really want to help you align with, what counts and to focus on what counts. I gave you the example of the privacy protection officer. I feel that this corner store doesn't really need a privacy protection officer. And I think this type of analysis could really help small and medium-sized enterprises. I mean, just stand in for them, pretend you're them, and ask, based on the data I'm collecting, this is not sensitive data. I mean, this is an important point. Small and medium-sized enterprises, it's really a matter of data. That's what it's all about, data here. So we need to look at what type of data is involved. And this has been taken into account in some of the clauses, but not everywhere. So simply, we need to align all this and to take this into account across the board. That will help. So you are an attorney. And in the legislation, there is the matter of setting up a tribunal. And Ms. Gordon as well, perhaps if you think this is relevant, you too could provide an answer. Or anyone else. But others have said look, forget it. Mr. Basile said it's, just useless. It's of no use whatsoever. Other witnesses have said that it will slow everything down. So what do you think of that aspect, the tribunal part? I'd like answers from a few of you. I don't agree. Frankly speaking, I think you just need to focus on the nature of the organization. The commissioner plays the role of an ombudsman. The tribunal plays a legal role, a jurisdictional role. I think that is an interesting approach. Let me look to what's going on in Quebec. Perhaps of interest to you, there's the Commission Access to Information in Quebec, which wears two hats, both oversight, which is sometimes a generalized approach to complaints and registrations and so on. And then a legislative element. There are judges who make decisions. I think that is helpful having two separate entities, and I think this is a good approach. Ms. Gordon?
On the topic of the tribunal, I do support that idea. I think that the current role of the privacy commissioner, I think that office has done an incredible job, but it wears many hats. So the commissioner wears the hat of an advocate, of an educator, does investigations, but what's always been said about that role is that it has no teeth. Whoever is in charge, they don't have teeth to implement fines and issue fines. So by having this separate role of the tribunal, that will allow for a more robust legislative process and will just allow the hats of the commissioner to be separate.
Monsieur Arbuckle, vous n'êtes pas avocat, je pense, mais avez-vous une opinion?
No, you're not an attorney, I think, but do you have an opinion? No? All right. Thank you very much. Mr. Gaillard, the floor is yours.
Chair, thank you to all the witnesses for making time for the committee. My questions are for Monsieur Guillemette. So I think you've answered this in piecemeal, but I wanted to give you the question sort of so you can approach it. But how does the CPPA align with other privacy and data protection regimes? And I want you to focus on the GDPR, given your expertise. Just overall, how do you think it compares?
There's a couple of things. I think that the first aspect is the idea of asking the organization to be able to explain what they are doing on the privacy side is very similar to the GDPR, what we are seeing at the moment. And I think it's positive in itself. The second aspect is there are some interesting legal bases and ways of making legal the processing of personal information. And I will give the example of legitimate business exemption. Unfortunately, and I want to say that they don't go as far as the GDPR, and I think this is something that should be considered at the very least. And then the third aspect, and I think it's important, is just the CPPA plays privacy as a key, as a cornerstone for our society, very similarly to the GDPR. And just I want to be clear that the GDPR has been a shock in Europe in itself. Everyone knew about it. It was an earthquake. I tend to think that the CPPA in its current version, with some improvement, could have the same effect and potentially pushing the organization to really, do even more, on the privacy side and relying on what they've been doing. So I think those are the elements that are common between the two regimes.
Thank you. How was the GDPR received by businesses in Europe? Was there a warm reception? Were they able to sort of get on board and comply?
So the first months were rough. Let's be honest. I think for everyone, they were just trying to adjust. And we have to keep in mind that it was May 2018. So it was the first biggest change in the world. And just to be clear, it's been the same across the world. So essentially, Brazil recently adopted their own privacy laws, Singapore. So it really was the beginning, let's put it this way. But then eventually, I think the regulators, in consultation with the organization, were able to essentially, make sure that organization would understand what was expected from them. And I think at this stage, there's a big aspect of expectation because the companies want to do well. And that's what I see in my practice. They want to comply. No one wants to say, well, you know what, we don't want to comply. But the problem is always, being clear regarding the requirement and being reasonable as well. So the GDPR now, at the moment, in North America, we are using the GDPR as a golden standard. In transaction between US and Canada, we are using language from the GDPR. So clearly, I think it just shows that it's been a success for Europe, if we are being honest. That's my position.
So in your second point, you had mentioned that the exception in the CPPA doesn't go far enough. Could you speak about the exceptions generally and maybe about the business purpose exception in particular?
Yeah. There's, and I'm sure I know you've been discussing this notion of legitimate interest. And I want to say that when we hear legitimate interest, it feels like, a free pass to do whatever we want. But I want to emphasize, if you look carefully at the CPPA, there is always an aspect of assessment, of explaining the why you can actually rely on legitimate interest. And the fact that we are limiting, for instance, for influencing the decision, we don't want to use legitimate interest. That's what we have at the moment in the law. I think it's a mistake because influencing could be bad or could be good. And I will give you an example. I have, for instance, my children online on social medias. They could see targeted advertising contextual without any context regarding alcohol or something I don't necessarily like as a parent. I prefer for them just to have specific, tailor-made advertising for children. That's what I prefer. And I think legitimate interest could be used, and it's the perfect segue between legitimate interest and children. I think those were topics that you've been discussing a lot, lately, as I understand. I think potentially legitimate interest is not evil. I think it's a question of documentation. And I'm going to give you the word that we use in Europe. Legitimate interest comes with LIA, legitimate interest assessment. So it's a document, a report explaining the why and how you are relying on this legal basis. I tend to think that the same could be done. And I think it's, yeah.
Great, thank you.
Merci, Monsieur Lemire.
Thank you, Mr. Lemire. Don't I appear at the end of the second round? Yes, it's a good thing to have a vice chair. You've just reminded me, Mr. Prickens, then.
This has been fascinating as the testimony has been on the whole thing. It's Dr. Guillemets, I think you've had 2 PhDs, as I understand it, so I think you've pretty much earned the doctor. You have a very impressive background, and I'd like to talk to you about 2 things. You seem to be getting all the popular questions here, but I'd like to talk to you about 2 things. One, the issue of consent we have raised before, and I've raised this in the committee before with other witnesses, the famous thing of what happened with Zoom in the summer, and I know from your resume, you seem to have done some work in the past for Meta. In Section 15.2 of their consent clause that we all click, and even most lawyers click onto without actually reading most of it on privacy. It says, you agree that Zoom may modify, delete, and make additions to its guide statements and policies and notices with or without notice to you, and for similar guide statements, policies, and notices applicable to your use of the service by posting an updated version of on the applicable web page. To me, that doesn't sound like consent. It sounds like I'm changing the terms without your consent. Is there anything in this bill that prohibits that practice?
So I'm going to emphasize the obvious. I'm here on my personal capacity to start. The second aspect is what you are showing at the moment is the limits of consent. That's what it is. Essentially, showing a big chunk of text and expecting the individual to consent. That's the reason why exemption to consent are interesting, because you will actually focus on the important moment of a data flow, where essentially if you want an express consent on biometric data, then you're going to ask for a consent. Those kind of things potentially could have been, it's my personal view, could have been captured by the notion of legitimate interest. And if the regulator, UPC, has any question, they can ask, knock on the door, why are you doing this? Show us the assessment. That's the reason why consent, to me, is not necessarily the solution. And it's not bad. I think it's globally, there's a consensus. Everyone understands that consent, we like the notion. I think it sounds good, but at the same time, it has limits. And if we want the meaningful consent, we should focus on express consent in limited situation. Otherwise, we will spend our time consenting and not meaningfully consenting. I think this is my
So if I could, because I have a limited time. So 15.5 says implied consent can be used, and you've talked about 18.3. When you pile all of these up and with Section 5, the purpose section, which says that company's interest is of the same value of an individual's right to protection of privacy, doesn't that weigh everything as a former marketer to me to be able to use and do what my company needs most over your personal interest. And again, if we could do it in about 30 seconds.
Or not necessarily, because the balancing is always, thinking about the rights and interests of the individual. So it's not something that you do, in a vacuum. There's an analysis of proportionality, necessity, and it's a long assessment. It's not a two-pager. So I think I think it's not only.
Thank you, Dr. Guillaume. Mr. Chair, I'd like to propose a motion pursuant, because I was poked by the bear. I wasn't going to do this, so I thought I'll do it anyway now. Pursuant to a request for documents passed by the committee on November 21st, 2023, the committee orders the Minister of Innovation, Science and Economic Development to produce unredacted copies of the Stellantis LGE battery plant contracts to members of the committee in both official languages. In other words, get it translated by Tuesday, November 28th. Further, that the committee pause the study of Bill C-27 until the contracts have been circulated. And the reason, if I could, Mr. Chair, for doing this is we all know that the government has hired over the last few years another 100,000 officials. Surely they can get, if the contract wasn't presented in both official languages, which surprises me that the government would not have contracts in both official languages before they sign it. I would request that all effort be made on this critical issue where such a large government subsidy has been involved and where there's such conflicting public reports on what's going on, that we get access as committee members on the terms that were outlined as MP Turnbull amended and as the Liberals voted for ultimately in that motion in our last meeting, that we get that French quickly and that it not take some undefined period of time for the government to present that, because we can't actually get on with the urgent nature of what it was that we passed at the last meeting without justifiably a French version and an English version of the contracts. And I think the government should treat with this with the most expediency and put all the resources they can in to address the needs of this committee. So I'm asking that they produce that translated document very quickly. And once we get that, we pause it for the day or two that we need so that we can look at that contract. This isn't a pause indefinitely, but to give us the opportunity, let's say we had it by Thursday, that instead of Thursday's meeting, we would have the day Thursday to take a look at those contracts, if that's the way it worked out. Thank you, Mr. Chair.
Okay. Just procedurally, Mr. Perkins, I understand you're giving notice of the motion. You're not tabling it, because if notice was not given to table drop a motion, it has to be on the topic that is discussed, and we're on C27. I understand there's one sentence at the end that would pause C27, but it's not precisely on the topic. So I'm tempted to say that this is more, that this cannot be discussed right now because notice was not given, but I'll hear you out, Mr. Perkins, on that.
And I appreciate that, but we are studying Bill C-27 now. That is the discussion we're having. We can ask any question we want to witnesses on Bill C-27, a very large bill. And this is about the relationship of two studies and Bill C-27. And if I could point you in the procedures book, the big green book as we all call it, to page 1061. And the reference there that allows us to reference the topic at hand that we're discussing, and that would be in order. And perhaps the clerk could take a look at that page, which I know she knows this book inside out because I've talked to her lots about it in the past. She's very knowledgeable about it. But if you would like, I can take a minute or I could read it in, but I don't think that's necessary, probably since the clerk has it. But page 1061.
Then I'll just take a couple of minutes to read it myself and determine if this motion is receivable as a motion that's table dropped on the floor like this. So I'll just briefly suspend. Apologies to the witnesses for that. Okay, colleagues, à l'ordre, chers.
I call you to order, dear colleagues. We will resume. Please.
Tabled by Mr. Perkins. After considering Mr. Perkins' arguments and consulting with the clerk as well, I'll note that our routine motions, which the committee voted on at the beginning of this legislature, and that were agreed by all parties, state clearly that a 48-hour notice interpreted as 2 nights be required for any substantive motion to be moved in committee, unless the substantive motion relates directly to business then under consideration. And I don't think that the motion before the committee right now that Mr. Perkins submitted substantively deals with the matter at hand, which is Bill C-27. But I understand then that this is notice given for this motion, and it'll be receivable at our next committee meeting on Tuesday. And on that note, Mr. Perkins, you still had a minute to for our witnesses. Otherwise, we can move to our next speaker.
Thank you, Mr. Chair, and thank you, witnesses. Mr. Goldfarb, I don't know if you're related to that famous pollster Goldfarb or not. You are, okay. He was one of the innovators of polling in Canada. So your father, I don't know if it's your father, but he did great work. As a I come at this as a marketing person when I look through this, and how much my colleagues, I won't say me, but my colleagues would push the envelope on analyzing data. And since this act is a brand new act, I'm talking about the privacy part. Since this act is a brand new act replacing everything, the hole that's there between the build-up in the same way that I mentioned to Dr. Gimi is from the purpose section through to Section 15 consent in 18.3, and I didn't mention Section 35, which allows the movement of data without a person's consent. It doesn't say limited to academic purposes like PEPITA does now. Doesn't that actually create a big hole that marketers can basically use to exploit to, combined with these weak consent provisions that are still there, allow companies to still utilize your data, change the terms of reference, create new data uses without your permission, and even in the case of harming you, as it says in 18.3. It can actually harm you. They can use it to harm you in 18.3 in that. Does it not do that?
Okay, so be a little careful. I'm not a lawyer. I'm an economist. As an economist reading this, in my view, the harms of data flows are well protected, while at the same time, businesses and other organizations are going to be able to use data in ways that allows them to deliver better products and services to individuals. And so now with the caveat, recognizing this, that I'm reading it with the eyes of an economist and not a legal scholar.
I don't know if I have. Even though that 18.3 says you can use it even if it harms the individual. And perhaps I would add that question to Dr. Guillaume too as well, as a lawyer on the issue of 18.3 allowing for the harms of data use even if it harms the individual. Sorry that I give you a moment to take a look at it.
technologies. I know
Sure.
they're very limited.
Has a potentially adverse effect so that a reasonable person would expect that to happen?
Yeah, so an organization has a limit that outweighs any potential adverse effect, harm, basically the individual resulting from that.
So again, in my view, given my expertise as an economist, the explicit recognition of trade-offs is positive, and the explicit sentence about this is what somebody would expect if they were interacting with this company together suggest a careful weighing of the trade-offs between the benefits of data flows and the benefits of privacy.
Thank you. And again, as well, I'm not allowed to deduct you, and maybe I could add one more caveat to it, which is that I think that the caveat that's always in here is a reasonable person. The question is there's a lot of people who aren't necessarily at that level in terms of their knowledge of the use of data. I think Europe actually may have a different standard that protects more vulnerable people than that term.
I can give you a very simple example regarding cookies. We've all heard about cookies on websites, and 10 years ago, cookies were something very new, something that people didn't understand. Now, 10 years later, more than this, actually 15, 20 years later, I think this is something that is well known by a reasonable person. So I think, and just to be clear, the fact that it's evolving is not bad. I think our laws are built on notion like this, where essentially we are making things evolved. What I see in 18, to be frank, is the assessment. And the assessment makes me feel more comfortable, being able to say, well, there's a rationale, it's being explained, it's being detailed, and it's not only, something just saying, well, you know what, I think, I have the legitimate interest. So again, I think I understand, those are valid concerns. I hear you. But at the same time, the world is changing fast. And I think we can do tremendous work with, I think C27 is full of potential, but we need to accept as well as the technology is going so fast that those kind of concepts needs to be embedded in the law. That's my position.
Thank you very much.
Monsieur Beauvais, I'll yield the floor to you because you've been patient.
Thank you. Mr. Perkins, I think that any data protection law is going to necessarily involve a weighing exercise. This is something that Mr. Goldfarb picks up on too. It's about weighing different interests. I think that a lot of work could be done actually in Clause 18(4)(c) in terms of the prescribed requirements as part of the conditions precedent if there are specific concerns there. So that's something that maybe the committee can think through quite carefully in terms of fixing specific things or addressing particular concerns regarding vulnerabilities of different users. And I would also note that vulnerability is indeed a concept which appears throughout the GDPR, in particular its recitals.
Are you talking about adding definition to C, or do it through the act or through regulation?
That the concerns could be dealt with in terms of prescribed requirements issued by the minister instead of maybe solidifying them into legislation itself. And that I think it's unreasonable to say that every single possible data use should not engender any sort of harm to any specific user. That is to say, like that would then be treating privacy as an absolute, and that to me, as someone who consistently advocates for robust privacy protections, that to me seems unreasonable.
Merci, MP Van Bynen. The floor is yours.
Thank you, Mr. Chair. My first question will go to Mr. Beauvais. Do you feel that Bill C-27 gives the Minister of Privacy, gives the Privacy Commissioner of Canada enough tools to ensure that the firms implement data management practices considering the sensitive nature of personal information about minors?
I would say that the bill, specifically the Privacy Commissioner's ability to issue administrative monetary penalties is a very welcome addition. The one thing that strikes me that I would like to highlight is the fact that the OPC cannot issue an AMP for breaches of Section 12 at the moment. And to me, I think that that's actually quite an important section, as the purposes of data processing are, the kind of pillar of determining what is a legitimate use of data or not. So I would recommend including Section 12 as a kind of enforceable ground for the OPC. Thank you.
Okay. Mr. Goldfarb, your thoughts?
Sorry, the particular question?
Oh, do you feel that the C27 gives the Minister and the Privacy Commissioner of Canada enough tools to ensure that firms implement data management practices considering the sensitive nature of personal information?
Okay, I want to be careful a little bit about my expertise in terms of the operations of it is not what I know well, but in my view, the bill is clear about what it gives the commissioner. If anything, I was coming in thinking the commissioner is getting a lot of power out of this bill to potentially interfere with how small businesses and startups operate. And so I do think it, if anything, it gets, I think it does get the balance right.
Let's come back to an article in September you co-authored and published on the economics of digital privacy, in which you state that digital privacy regulations can, and I quote, can have negative consequences on market outcomes, particularly with respect to competition, innovation, and both producer and consumer surplus. Do you think Bill C-27 should be amended to protect the competitiveness of Canadian businesses?
I think it's, in my view, in many ways, the most important thing about my policy and to some extent privacy policy is to ensure that we protect competition. At the same time, in this act, I don't know what an amendment would look like that would protect competition in terms of that next generation of technology. A vigorous antitrust enforcement by the Competition Bureau, and the continued vigilance on how large tech companies and others are potentially using their existing dominance in some markets to connect to and take advantage of new markets is worth protecting. I'm not sure that belongs in C-27.
Competition Act?
In the sense of things like ensuring interoperability between existing systems and new technologies are very valuable.
We're looking at some.
Sorry.
We're looking at some pretty significant imbalances in the economy, where you have dominant players in relation to big data and resources in terms of financial resources. What are the things that we should be considering that levels or at least brings into better balance the competitiveness of those imbalances now? The concern that I'm hearing through the HUMA committee is that this will be a polarization of capital, and the gap between the haves and the have-nots will become quite significant. How can we address some balancing there?
Okay. So we think about technology and technological change. Information technology, it's capital, and so the owners of that capital have done better and better. And that's this whole literature on the decreasing labor share and the increasing capital share of the economy is partly related to the ability to scale through information technology. These particular data-driven technologies, the impact on market power is more subtle. And the reason is because In a stats 101 sense, I don't know if and when you took statistics, but your predictions, there's decreasing returns to scale and data in a like formal technical sense. As in, if you have 10 people and you get an 11th, you learn a lot. And if you have 1 million people and you get one more, you don't learn that much. And so in an explicit technical sense, there are not economies of scale and data. And so on data-driven and machine learning technologies, there's reasons not to expect monopolization. There are, importantly, other forces going in the other direction. And those are the things we should keep an eye on and regulate. The forces going in the other direction are things like the ability to use data requires certain other technologies or can benefit from certain other markets where there is dominance. So the ability to use data and use it well requires compute. And so if the cloud services market is monopolized or has strong market power, that's going to impede innovation and be a real competition worry. Or if media in some ways are monopolized and therefore the ability to understand users as they interact with media becomes monopolized, that's another way that could create in terms of competition. So, but those, in my view, those are related, but only tangentially related to most of the content of Bill C-27.
Thank you.
Mr. Van Bynen, I'm afraid you're out of time, and that concludes our third round of witnesses of questioning. So we'll be ready to adjourn the meeting. Monsieur Massé.
Thank you, Mr. Chair. I don't get my last spot, and that's okay. But I do want to say thank you. I appreciate your decision on the ruling. I think it's the right ruling in terms of the practice that I've seen here. But I do want to express a little bit my concern about the situation of the topic of the jobs. When I came here on Monday, I was mocked by some members in the House of Commons because it was one job that was saying that was going to be, to those of South Korea. We learned on Tuesday it was 100 jobs. We learned today that there may be another 900 jobs that are possibly, it's breaking right now, and then there's also the question of 1,600 jobs before that. So we still don't know the jobs for building, tech transfer, and operating, and I think those are all public trust issues that we should be getting to at some point, and I appreciate your efforts to steer us through this because, in my opinion, these are important investments to be made, but there needs to be some confidence in the public trust because it's not only just about the plant that's local in my community, but the three ones that come after that. So I appreciate your ruling. I do think I want to put on the record, though, that I think it was the appropriate reading given the practice and the importance of the matter will be there next week. Thank you, Mr. Chair.
Thank you. No, we're not opening a debate. We're not opening a debate. Mr. Massé agreed to forfeit his last 2 minutes of questions because we ran out of time. So I recognized him. And just to be clear, I'm hoping that we're going to get the contracts very soon, and I understand they're being worked on by the department. And on that note, thank you very much to the witnesses for your presence here today. Merci aux interprètes, au personnel de soutien.
Thank you to the interpreters and the support staff and the analysts.
Oh, thank you. Nice seeing you, Ari.